First Amendment. Is the Human Trafficking Prevention Act an unreasonable encroachment on the freedom of speech? The answer is absolutely not. The United States Supreme Court has over and over again found that pornography is unprotected, harmful speech, and Congress and the state legislature can regulate the time, place, and manner of speech, especially unprotected, harmful speech. And this bill does not get rid of pornography, prostitution hubs, child pornography, and revenge pornography. But what it does do is it takes child pornography, revenge pornography, prostitution hubs, and obscenity and puts it behind the blinder rack, a digital shield, so where it's just a little more inconvenient to access it. And so it's basically been a narrative of the tech companies to say that if they get regulated at all, it's violating the consumer's freedom of speech rights. It's completely ridiculous and intellectually dishonest argument. I mean, this matter really has nothing to do with the First Amendment. The real freedom interest here is in the ability for consumers to choose to have access to content or not to choose, instead of having the tech companies patronizingly make that decision for them. This isn't about the First Amendment. This is about allowing consumers the fundamental right to regulate their own mental health, making the objectively healthy choice the easy choice. And of course, minors should have no say, and minors should have never been in a scenario where they can be exposed to pornography by buying filterless products. That is a crime of distributing pornography to minors. Also, there are basically two controlling Supreme Court cases that demonstrate insurmountably why this act does not violate the First Amendment. And before this bill came about, there was multi-state litigation brought against Google, Apple, Microsoft, Samsung, Verizon to force them to make their best arguments for why they shouldn't be regulated. Their arguments are literally laughable. There's two cases that they're not able to get around, and they won't be able to get around, and those cases are Ginsburg of 1968 and Ashcroft versus AM Civil Liberties Union, 2004. Both of those are Supreme Court cases. The Supreme Court in Ginsburg held that the display statutes, which all states have, are constitutional. There's a legal analogy that applies here squarely, and that is if a physical display statute, which regulates bricks and mortar stores, physical stores, and requires those stores to put physical pornography behind a physical filter blinder rack that can only be removed by the retailer if the consumer is over 18, then a digital filter law that regulated digital stores, which products that distribute the internet are, and made the manufacturer and retailers of those products to have to put digital pornography behind a digital blinder rack, that too would be constitutional under Ginsburg exactly. And there's no way around that. Moreover, the Supreme Court in Ashcroft found that filters were the least restrictive means, and that Congress and the legislatures have the right to present filter legislation that would regulate the handful of tech companies. The problem with the Communications Decency Act and the Child Online Privacy Protection Act is that they tried to regulate either individual consumers or individual content creators only within the United States. So this bill finally will regulate the right party. The tech companies have spent untold amount of money to avoid regulation. They have completely hoodwinked the population and twisted these matters. They have shoehorned these matters into First Amendment narratives when they are not. It is totally intellectually dishonest, and it's time that it stops. The court precedent is on our side. The legislatures have a duty to protect the public health, and no business wants to be regulated, but the legislatures can set a safety standard, and it can be up to these businesses to comply with it. These businesses should comply with the obscenity codes, and there should be no double standard.